Hello everyone, this is Dhanashri Chougale and you're watching Ganga Education. Welcome back to my channel. On this channel, you will get information regarding law and competitive examination related to law. So subscribe my channel and hit on a bell icon so that you can get information regarding upcoming videos. So stay tuned. In this video, we will get information regarding to Civil Judge Junior Division Judicial Magistrate of First Class Preliminary Examination held in 2012. This video series will be in 4 parts. We will discuss question number 1 to question number 25 in this video. This is question paper of Civil Judge Junior Division and Judicial Magistrate of First Class Preliminary Examination. The examination was held on 16th of September 2012 and this is set A. We have already discussed the instruction while studying 2011 paper, so we are not going to discuss it again. Let's jump on questions directly. Question number 1. Summons of court can be served by option number 1. Only a police officer. Option number 2, an officer of the court. Option number 3, public servant. Option number 4, any of them. And the correct answer is option number 4, any of them. Now question number 2. Under Code of Criminal Procedure, substituted service of summons can be made. Option number 1, by a registered post. Option number 2, by courier. Option number 3, by affixing summons on the house. And option number 4, none of it. And the correct answer is option number 3, by affixing summons on the house. Now question number 3. Under section 97 of the Code of Criminal Procedure, search warrant to find out a person can be issued if option number 1, the person is absconding. Option number 2, the person is unlawfully confined. Option number 3, the person is missing. Option number 4, whereabouts of such a person are not known. And the correct answer is option number 2, the person is unlawfully confined. Now question number 4. Under section 107 of the Code of Criminal Procedure, executive magistrate can obtain bond from a person if option number 1, the person is habitual offender. Option number 2, a person is likely to abscond. Option number 3, the person is likely to commit a breach of peace. Option number 4, the person frequently quarrels with his neighbor. And the correct answer is option number 3, the person is likely to commit a breach of peace. Now question number 5. A divorced wife is entitled to maintenance from her husband. Option number 1, till she remarries. Option number 2, till her son becomes a major. Option number 3, till she is employed. Option number 4, till her death. And the correct answer is option number 1, till she remarries. Now question number 6. Executive magistrate can put a party in possession of immovable property. Option number 1, upon a police report that a dispute in respect of such property is likely to disturb public peace. Option number 2, if that party is dispossessed unlawfully. Option number 3, if the rival party denies to deliver possession of the property though such party is owner of it. And option number 4, none of the above. And the correct answer is option number 1, upon a police report that the dispute in respect of such property is likely to disturb public peace. Now question number 7. In a private complaint, case process can be issued against an accused after option number 1, complaint in writing is presented to the court. Option number 2, complainant's statement on oath is recorded. Option number 3, the magistrate is of the opinion that there is sufficient ground to proceed with the case. Option number 4, police upon investigation submit a report that there is sufficient ground to proceed with the case. And the correct answer is option number 3. The magistrate is of the opinion that there is sufficient ground to proceed with the case. Now question number 8. Any defect in charge, option number 1, can be cured by amending it in any case. Option number 2, cannot be cured if such amendment is likely to cause serious prejudice to the accused. Option number 3, can be cured by amending it though it causes prejudice to the accused. Option number 4, can be cured by amending it with the direction of retrial if such amendment is causing prejudice to the accused. And the correct answer is option number 4, can be cured by amending it with the direction to retrial if such amendment is causing prejudice to the accused. Now question number 9. Statement of an accused is recorded, option number 1, to give him opportunity to state his defense. Option number 2, to enable him to explain circumstances appearing in the evidence against him. Option number 3, to extract the truth from his mouth. Option number 4, to verify whether he can be released on probation. And the correct answer is option number 2, to enable him to explain circumstances appearing in the evidence against him. Now question number 10. The court, on application for plea bargaining by the accused, to satisfy itself that it is made voluntarily. Option number 1, examine him in open court. Option number 2, examine him in camera. Option number 3, records his evidence on oath. And option number 4, seeks his affidavit. And the correct answer is option number 2, examine him in camera. Now question number 11. Decree means, option number 1, extract of the judgment. Option number 2, bill of costs. Option number 3, reasons for which the suit is decreed or dismissed. Option number 4, formal expression of the court of an adjudication determining the rights of parties. And the correct answer is option number 4, that is formal expression of the court and adjudication determining the rights of party. Now question number 12. Judgment means, option number 1, part of a decree. Option number 2, statement of judges on the grounds of decree or order. Option number 3, adjudication of right. Option number 4, none of the above. And the correct answer is option number 2, that is statement of the judges on the ground of decree or order. Now question number 13. If objection to the jurisdiction of the court is taken at the hearing of any application for interim relief, the court shall proceed to, option number 1, the trial of the suit immediately. Option number 2, frame the issues. Option number 3, decide interim applications before framing preliminary issues of jurisdiction. And option number 4, to determine issue as to the jurisdiction. And the correct answer is option number 4, to determine issue as to the jurisdiction. Now question number 14. Res judicata means, option number 1, staying the suit during pendency of the previous suit between the same parties involving similar issues. Option number 2, not trying the suit if suit involving similar issues between similar parties is decided. Option number 3, bar to further suit. And option number 4, expediting trial of the suit. And the correct answer is option number 2, not trying the suit if suit involving similar issues between similar parties is decided. Now question number 15. Objection to the territorial jurisdiction of the court can be allowed if it is raised, option number 1, at any stage of the trial. Option number 2, at any time before the plaintiff leads his evidence. Option number 3, at the earliest possible opportunity and before issues are settled. And option number 4, even at the stage of appeal. And the correct answer is option number 3, at the earliest possible opportunity and before issues are settled. Now question number 16. In case of decree for the payment of money, the court can order interest at the rate of option number 1 6% per annum, option number 2 12% per annum, option number 3 9% per annum, option number 4 15% per annum, and the correct answer is option number 1 6% per annum. Question number 17. Under the inherent powers of civil code, it can pass orders. Option number 1 to refer the matter to mediator. Option number 2 necessary for the ends of justice or to prevent abuse of the process of court. Option number 3 for compelling the parties to settle their case. Option number 4 for compelling a plaintiff to withdraw his suit. And the correct answer is option number 2 necessary for the ends of justice or to prevent abuse of the process of the court. Now question number 18. Defendant can claim temporary injunction in a suit filed by the plaintiff. Option number 1 to prevent the suit property being alienated or damaged. Option number 2 to prevent the plaintiff from dispossessing defendant from the suit property. Option number 3 to prevent the plaintiff from causing any legal injury to the plaintiff, and option number 4 all of the above. And the correct answer is option number 1 to prevent the suit property being alienated or damaged. Now question number 19. The defendant shall present his written statement within dash dash days from the service of summons upon him. Option number 1 90, option number 2 120, option number 3 30, and option number 4 60, and the correct answer is option number 3 30. Now question number 20. Where any period is fixed or granted by the court for doing an act prescribed by the Code of Civil Procedure, the court may enlarge such period. Option number 1 not exceeding 90 days in total. Option number 2 not exceeding 30 days in total. Option number 3 not exceeding 60 days in total, and option number 4 not exceeding 120 days in total. And the correct answer is option number 2, that is not exceeding 30 days in total. Now question number 21. Where a 30 years old document is produced before the court, it may presume option number 1 that the facts stated in the document are proved. Option number 2 that the document is duly executed. Option number 3 that the content of it are proved, and option number 4 all the above. And the correct answer is option number 2 that the document is duly executed. Now question number 22. A document can be proved, option number 1 by producing it before the court. Option number 2 by examining the party who has produced it. Option number 3 by examining the person in whose handwriting the document is written or signed, and option number 4 by examining the person in whose favor the document is executed. And the correct answer is option number 3, that is by examining the person in whose handwriting the document is written or signed. Now question number 23. A confessional statement made before police. Option number 1 is admissible. Option number 2 is not admissible. Option number 3 is admissible only if it relates to the facts discovered in consequences of it, and option number 4 is admissible if it is made on oath in writing. And the correct answer is option number 3, that is admissible only if it relates to the facts discovered in consequences of it. Now question number 24. Admission is option number 1 a conclusive proof of the fact stated therein. Option number 2 not a conclusive proof but operates only as estoppel. Option number 3 a weak piece of evidence, and option number 4 an evidence on which the court can act. And the correct answer is option number 2, that is not a conclusive proof but operates only as estoppel. Now question number 25. Admission means option number 1, statement made before court. Option number 2, statement made in a document. Option number 3, statement suggesting inference as to any fact in issue. And option number 4, none of the above. And the correct answer is option number 3, statement suggesting inference as to any fact in issue. That's it for this video. We have discussed question number 1 to question number 25 in this video. In next videos, we will discuss remaining questions. So, thank you for listening.